आवाज आ रही है?
Hello,
हाँ जी।
this is Webcast
हाँ, ओके,
from the
ठीक है।
Panchayati.
जी हाँ, जेएस मैम रूरल डेवलपमेंट से जुड़ी है, वहाँ से आवाज़ मिल रही है?
Oh, oh my God.
You're
नमस्कार
audible.
सर। हरियाणा पुलिस अकेडमी से एक बार ऑडियो वीडियो चेक करेंगे सर।
जी जी सर, मिल रही है सर।
थैंक यू
जी आ रही
सर।
Sir,
है।
this is from the Ministry of Panchayati Raj. Are we
जी,
audible?
यस यस
Yes, yes, you're audible.
Thank you.
A very good morning to all those who have joined this second webinar on the discussion relating to the three new criminal laws which have been enacted by the Parliament and are very shortly due to come into force. We are joined today by respected Vivek Bhardwaj sir, Secretary MOPR, by Ma'am Smriti Sharan, Joint Secretary of the Ministry of Rural Development, and let me introduce myself. I am Dr. Preetham Yashwant, Joint Secretary, Ministry of Women and Child Development, and with me are my colleagues. right at the outset, I would request Vivek Bhardwaj sir to please set the proceedings in motion today with your opening remarks, sir, on these three criminal laws, which are a momentous decision and a momentous time in the criminal legislation in our country.
Friends, I hope I am audible.
Yes, you are.
See, we are prone to using the word transformational very often and in a very loose manner. But this is truly transformational. We are yet to understand the huge impact this would have. I had said earlier also that these laws are being transformed, changed, adapted to a new India after more than 150 years. The CRPC dates to 1860. And remember the background of the old colonial laws, they were enacted right after 1857. In fact, our police commissionerates came into being in the East India Company time. They are not a modern phenomena at all. So this is something which was long overdue, and I heartily congratulate MHA for this momentous step that they have taken. I was part of MHA once upon a time, at that time when the Honorable Home Minister was very eager to ensure that this happens. It was his quote unquote a dream project, and kudos to him that he has actually been able to implement his vision. It has taken a lot of effort. Huge consultations have taken place with various stakeholders, and the net result is something that we should all be proud of. There would always be teething problems, and I'm sure they will get sorted as we go by. I will give you a very small example of how a fine balance has been struck. At one end, lodging an FIR has been made very easy because now it is going to be online. On the other hand, the police has 15 days to check the veracity of the complaint. So false and frivolous FIRs are sought to be prevented by this 15 days window. Now we may think that these are laws which may not impact us, but anyone who holds property is going to be impacted. Anybody unfortunate to have seen bodily harm will get impacted. And panchayat functionaries are political leaders at the grassroots. They really need to know this because they are the ones who will be guiding their brethren. There are many issues which arise at a village level. There is domestic violence. There are unfortunate incidents with women. Children go missing. There's trafficking. All of this is very well dealt with in the new criminal laws. And I am very sure that this session, which has been organized by the three ministries jointly, is going to be of great help to our Panchayati Raj functionaries. Thank you.
Sir, we thank you so much for your words of wisdom, and you have set the tone for this important discussion. These laws come into effect from 1st July, and they focus on improving the criminal justice system with an increased emphasis on access to justice, victim centricity, gender neutrality, and timely disposal of cases, with the additional major input of involving technological advancements into the criminal adjudication system, and to tackle with cybercrime, and to further increase the systems in which organized crime can be also tackled. And all these provisions have a direct impact on crimes committed against women and children. With this, I request our next speaker, Ms. Smriti Sharan, respected Joint Secretary from the Ministry of Rural Development, to say a few words.
Respected Secretary MOPR Bhardwaj sir, my colleague Preetam Yashwan, and all the colleagues who have joined from across the various parts of the country, particularly everybody who's joined from the villages, from the panchayats, from collectives, and especially our DDs from the self-help groups. Namaskar to all of you. It is indeed an absolute privilege to address all of you on this day. And as Secretary MOPR has said, that this move towards the 3 new laws is truly transformative. And therefore, all the country folks who've joined across the country, this is just to tell you that you're going to be part of a very transformative process in the making. As you're aware, the Deen Dayal Antyodaya Yojana National Rural Livelihood Mission has over the last decade placed a lot of emphasis on community architecture and has very systematically, with your support, built a pyramidal structure where the foundation is laid by creation of self-help groups, which is then followed by village organizations and finally the cluster level federations. This organized structure in the last 10 to 11 years has shown it to the nation that you people have the capability as well as the resolve to change your situation, economic situation, the physical situation around your village, and also to be able to see dreams and then accomplish them. With your effort only, we've mobilized 10 crore households, which have been tied into 91 lakh self-help groups, 5 lakh village organizations, and 32,000 cluster level federations. While we augment livelihoods, which is our main work, we've been tackling a lot of core issues like hunger, nutrition, and also a very, very focused attempt on gender issues. In our endeavor to eradicate poverty, we've understood that gender-based violence is a major peril which hinders social and economic development of both women as well as the larger society. We've been systematically placing various mechanisms with help of our partner ministries and also within our own program, where we've set up gender resource centers, and we've built up capacities of the cluster level federations to identify and take action to resolve issues such as gender-based violence, issues which are related to gender-based violence. We've set up more than 3,500 gender resource centers, which work like a one-stop place where all your issues, information, the required information, and the resolution-related issues are tackled at these gender resource centers. All of you must be aware that in partnership and in true spirit of convergence, we've done 2 successful years of Nai Chetna, which is a specific campaign which we'll run during the months of December and January, which tackles the issue of gender-based violence. And now, in our next step, in convergence with the Department of Justice, we are now also going to train our self-help group women to become paralegals so that they understand what is violence, what is gender-based violence, and how best to prevent it and to safeguard the interests of the women at large. With our experience on the ground, we have also understood that a violence-free future can only be enabled if we have legal literacy in large doses. The 3 new criminal laws, which have been spearheaded by Ministry of Home and has been facilitated to by WCD to spread awareness amongst all of us. The 3 new criminal laws will help shift the focus to emphasize on access to justice. It will focus on victim centricity, gender neutrality, and timely disposal of cases. To advance this, we at MOPR, WCD, and MORD have resolved to work together, and this joint webinar is the first step in that direction. I believe that the webinar will be very effective, especially amongst our SHG members, in spreading the awareness and also making them aware of the legal provisions that will safeguard their interests with greater emphasis. A joint effort on gender sensitization is just the first step, and we'll collectively amplify this work. We are committed to jointly create pathways for increased legal access, legal literacy, and access to justice. I place on record our deepest appreciation to Ministry of Women and Child Development for having spearheaded this whole conversation and collecting so many of us in this conversation, and we will continue to give us our best support. Thank you so much. Thank you, sir.
Thank you, ma'am. And from my side, I would just like to bring to the notice of all the thousands of people who have joined today that we had a similar webinar on 21st, that was last Friday, in which we were overwhelmed by the number of people from all walks of life who joined together across the country. Our last reports have suggested that more than nearly 50 lakh women, men, and across the country joined in to listen to what is it that is changing in the entire scheme of things in criminal legislation. And it also encouraged us that that the entire field functionaries of all our 3 ministries, Ministry of Panchayat Raj, Ministry of Rural Development, and of Women and Child Development, worked so assiduously in trying to send this message across to all their stakeholders that it is something that they should listen and at least come to know that something is happening. Similarly, today, for the benefit of all those states where their first language or their medium of communication is not Hindi, we've organized a special webcast in English. We understand, I must place on record right at the beginning, to all our friends and all our colleagues, all our frontline workers from, whether or southern states like Tamil Nadu, Kerala, Karnataka, Andhra Pradesh, Odisha, Telangana, and so on, and our friends from the Northeast, all the Northeastern states, that we understand that we have made, there is a provision right at the beginning of the webinar. I'd like to just tell us that NIC has a provision that in the webcast link, there is a little button which says choose your language, and it is available for translation right now in 6 languages at least as a subtext. But I assure all of you, all our friends from all the regional states who are non-Hindi speaking, that this is only the beginning of the conversation, and all our material has been shared with all states and union territories, and we encourage them, and we are willing to support them to have all the material translated into regional languages. And in the next few months, as we go forward, we request and we encourage that in the state regional training institutes of all the 3 ministries, or at the divisional level, or even at the district level, that a translated literature is made available in very easy to understand simple language, so that women in particular and all populations, all citizens in general, come to know what are these major provisions which have changed and how does it impact their lives. I must add, before I close my remarks, that we have more than 800 one-stop centers which are now a footprint across the country, mature institutions, at least one in every district of the country. I thank all my colleagues in the one-stop centers who are working so hard to be the first point of assistance to women in distress. For you, this education is also very important so that you can spread the word in and around your vicinity, in and around your jurisdiction. I also thank the Hubs for Empowerment of Women, a new fledgling organization now with a footprint of more than 700 districts across the country. You're just emerging, and your role is primarily for creating awareness about all the benefits and schemes which the government has to offer, especially to women. But at the same time, your role also includes that to spread information about new legislation, which is the central point of today's discussion. And I cannot close without saying thank you to all our Anganwadi Didis, more than 14 lakh of them all across the country. You are our frontline workers, you are our strength, you are the base on which the entire ministry stands and succeeds in every endeavor. So to all my Didis who are perhaps conversant in English today, since today's webinar is in English, in the Northeast especially and in the southern states, I thank you very much for your continued efforts in taking forward the journey of development and empowerment of women in this country. With that, I must introduce my two colleagues, capable and very well versed with the subject at hand. On my left is Ms. Aditi Tripathi. She is an advocate and a resource person who has been associated with the formulation of these path-breaking transformations in the criminal laws, which are to be notified on July 1st. And she will very lucidly, very simply, and touch upon all the specific provisions of the law which have a major impact on the lives of all the women and children across our country. And later on, it will be followed by some more insights into these legislation, the provisions of these legislations, by my colleague, Mr. Dayashankar, who sits on my right, who is a director in the ministry and deals with all matters relating to women welfare. With that, I hand it over to you, Ms. Aditi Tripathi. Thank you.
Respected Secretary of Panchayati Raj, Ministry of Panchayati Raj, Mr. Vivek Bharadwaj, respected Joint Secretary, Dr. Preetam B. Yashwant of Ministry of Women and Child Development, Madam Smriti Sharan, Joint Secretary of Ministry of Rural Development, and Director Shri Daya Shankarji of Ministry of Women and Child Development. Very good morning to all of you. Namaskar. It is my great privilege to be talking to you today about the 3 new criminal laws that have been passed by our Parliament in December 2023. In a few days from 1st July, these laws will be applicable to each and every citizen of this country. Now, criminal laws are such laws that are valid upon and that affect the lives of every citizen of this country. They are not special laws. After a very prolonged study, we have come up with new laws. Why? So the question arises, what was the need of having these new laws? So if you look at the current criminal justice system, it is governed by laws that was given to us by the Britishers when they were a colonial power over India. So if you look at the Indian Penal Code, the Indian Penal Code dates back to 1860. So in my law college, when I first started studying IPC, I was also very confused about why do we have laws that were given to us by Britain and why are we still moving ahead with these laws. It is important to understand that these laws were formulated by the colonial power for the colonial power. It was to protect their own interests. It was to ensure that the subjects, that is the general population over which they were ruling, can be controlled, can be punished, can be demoralized. They prioritized punishment over justice, so the element of justice was really missing in these laws. Secondly, why there was a need is because these laws are colonial. Imagine a penal code, a legislation which provides offences was made in 1860. So the Indian society at that time was very different. Today, how we stand as a society, we are very different. And over the years, we have seen that this system is rigged with a lot of problems. One problem is that there is no certainty as to when a criminal trial will come to end. There is less accessibility where, because of lack of legal awareness and also because of certain difficulties in procedures, it is difficult for a common person to have access to law enforcement agencies or to have access to even basic documentation that pertains to their cases. Secondly, there was a lack of transparency that was felt. And this lack of transparency also is also reflected in the fact that the kind of evidence that is collected does not end up being credible enough at the end, by the end of the criminal trial. So all of these problems were looked at, and it was thought of what can be done to find a solution to these problems. So there was a study, a deliberation that spanned over 4 years. People from all sects of society which are affected by this, who are the prominent stakeholders, be it the general public, be it judges of district courts, high courts, supreme courts, MLAs, MPs, legal professionals, advocates, forensic experts, information technology experts, police, and other law enforcement agencies. All of their suggestions were invited. All of their suggestions were then deliberated upon by a committee of experts, which planned to create a system which does transform the existing criminal justice system, but it does not happen at the cost of uprooting the system that we have today. So these laws are made to adapt to the current system and ensure that the current system gets modernized slowly and slowly. So if we look at what the new legislations have brought to us, certain things come out prominently. First is its victim centricity and ensuring that these are public-centric laws which ensures access to justice and protection of the rights of victims and public. So for this, one of the most important changes that have been introduced is pertaining to how we file an FIR. So say an offence has occurred. Currently, what is required by a person if they want to file a report against that offence is that they go to the jurisdictional police station of where that offence has occurred and then file a police report there. So a lot of times this led to a lot of corrupt practices, and a lot of times due to lack of awareness and lack of knowledge, people did not know about which police station to go. Say the offence happened somewhere else and they live somewhere else, it became a difficulty to go there, attend proceedings in the police station when you're called as a witness to give your statements and other things. So this problem has virtually been done away with, because now they have introduced something called a zero FIR, which means you can file a police complaint in any police station, regardless of where the offence has occurred. Second and most important change is that now you can file the information of an offence even through an online medium. So by the use of your computer, your phones, you will be able to file your police complaint, and once you file a police complaint through online electronic means, you will have to go to the police station within 3 days to sign the report. But this is done so that the police is sure that an offence has occurred and an investigation needs to start forthwith. Say in a situation where your police FIR is not being registered even after the introduction of zero FIRs and EFIR, then you have the opportunity of going to the superintendent of police, writing a complaint to him and asking for his intervention. He will assess the situation and ask a subordinate officer to conduct investigation. Say if you do not find relief even over here, then you have the option of going to a magistrate and filing a complaint with the magistrate, seeking the intervention of the court's wisdom, and then the court can ask the police to conduct investigation. So these are certain very important changes that have been brought about, which will strengthen the rights and protect the rights of public and victims. Secondly, it has been said in law now that the victim or the informant has to get a free copy of the FIR from the police station. So the protection of the right to information is instituted at the very beginning of this process. Secondly, women who have suffered, who are victims of certain sexual offences like rape and gang rape, in those situations, a lady police officer has to record their first information report. In cases where there are individuals who are mentally or physically disabled and their movement is highly restricted, in those cases, a police officer has to visit their place of residence or any place that they are comfortable in with the assistant. They can have their parents, relative, or social worker while they are giving their statement to the police officer, and such a proceeding may also be recorded to ensure that no abuse of power is taking place at this point. Secondly, once the police report is registered, a lot of times witnesses are called to the police station to answer a few questions, to assist in the process of investigation. Now, a change has been introduced in this as well, that if you are a woman or a male person below the age of 15, so effectively a child, or a male person or any person above the age of 60 years, or anybody who's suffering from an acute illness. So women below the age of 15, above the age of 60, and anybody who's suffering from an acute illness do not have to go to the police station in case the police wants them to come there to give certain statements. In this case, the police will come to wherever they are comfortable in giving such a statement. And if these people still wish to go to the police station, there is no restriction over that. But in case they are unable to, then there has been made a provision that the police will come to where they are and where they are comfortable to get their witness statement. One of the most formidable, most important change that has been introduced to protect the rights of the victim is that no case can be withdrawn by the prosecution without hearing the victim first. So a lot of times before, because of circumstantial, environmental pressures, political pressure, any other kind of pressure, the prosecution would withdraw the cases without even intimating the victim. So a victim has been made central to this criminal justice system, and no court can allow the prosecution to withdraw the case without listening to the victim, and the victim will be given a completely free and fair chance to put their point across so that it is on the record, it is heard, and their rights are protected. The second important point that comes across from these three legislations is that there is a significant push to make the system more accountable and transparent. So for this, technology has been leveraged in a fantastic way. So a lot of procedural things like servicing of summons, notices, warrants, supply of documents, all of these things used to take a lot of time because they used to be done manually. So now electronic medium has been adopted for these things. Electronic medium has also been adopted for presenting yourself in court if you have to give a statement or you have to be cross-examined or you have to depose evidence. So anybody, victim, witnesses, any public servant, any expert, they can now go to a place that will be designated by the state government, and they don't necessarily have to go to the exact court premise where the court is happening. So this also, in cases where people are not in the same jurisdiction of the court, they do not have to travel for the purposes of giving their evidence. Hence, this brings about a lot of convenience, and this also speeds up the process of court proceedings. Secondly, to bring about accountability, one of the most important things that has been done is that once you file an FIR, within 90 days, a police officer has to inform you about what progress has the investigation taken, what steps have been taken, what are going to be taken. The victim will be informed fully about this within the first 90 days of filing the police report. Similarly, for the first time, forensic experts have been mandated. Now it is necessary that forensic experts go to the crime scene in case of heinous offences. Heinous offences being those offences which are punishable for more than 7 years. So now forensic experts have to go to that crime scene, collect evidence. What this does is that field experts are now handling forensic evidence from the first day onwards. it also leads to a better preservation of such evidence. So there is less likelihood that such evidence can lose its credibility by the end of the trial. So these are important measures introduced to ensure that the credibility of evidence remains throughout this trial. And it is understood that forensic capabilities are still growing in our country. They are not at the level at which we require. So a period of 5 years of time has been given to state governments to develop this capacity. In the meantime, a state government which does not have a forensic facility can obviously take help from neighboring states. It can take help in the in terms of assistance from forensic experts or laboratories. So this is one step taken which will slowly push us into a more technologically adept criminal justice system, which will ensure that technology is used to finally resolve crime as well. Second, another point about increasing accountability and increasing transparency in the criminal justice system is that any search and seizure proceeding that is now conducted by police has to be audio-video recorded. In fact, starting from the search and seizure proceedings, after that, even when the list of items is made, witnesses are called, or the entire process has to be recorded through audio-video electronic means, which will be used as evidence later when the question about the search and seizure proceedings comes in the trial. Another very important measure adopted to ensure that accountability and transparency is maintained is by introducing timelines. So, like I said before, there is very little certainty as to when a criminal trial is going to get over, is going to come to some resolution. Now, this can be a very distressing situation for most people because A, there is a criminal trial that you have to be a part of. B, there are expenses involved in this. C, there is, most importantly, a prolonged wait for justice. So to ensure that certain proceedings, certain stages are not left to happen at any pace, they have been put strict timelines. So things like filing of discharge petition, framing of charges, in how much time should the judgment come out. All of these things have been given prudent enough deadlines. It's not like they have completely made the system so fast that justice does not get a chance to be delivered. But also, inordinate delays have to be stopped. So, reasonable timelines have been put to all of these processes. Offences against women, sexual offences against women like rape and gang rape, sexual offences against children, certain provisions of POCSO have been mandated to be completed. The investigation of such crimes have to be completed within 2 months of time. In the offence of a rape, a medical practitioner has also been time bound to give his or her medical report within 7 days to the IO. So it's police, medical representatives, courts, all have been bound by time to ensure that there is consistency in a criminal procedure, in a trial or investigation processes are happening at a consistent state, and at every time the victim is informed about what is happening. So technology has also been used to supply documents, say, and all documents that are now going to be submitted in a court of trial, both the accused and the victim will have full entitlement to get free copies of those documents. This is very important because before this, there was no such provision. So a lot of times, a lot of the documentation that was presented in court, both accused and the victims had no access to it. So now this has ensured that the right to information is ensured in a courtroom, in a process of criminal justice delivery. A very compassionate view has also been taken for people who are vulnerable and people who are vulnerable to commit crimes. So the criminal justice system has to strike a balance between victims and accused. It should not be accused-centric, but it should also not let go of any responsibility towards the accused. So certain important compassionate provisions have been introduced in the new criminal laws, which will ensure that there is more attention paid on rehabilitation, and there are steps taken to reduce the chances of a person recommitting a crime, recidivism, what we call. So a lot of efforts have been put in ensuring these two goals as well. So first, community service has been introduced as a form of punishment, a non-custodial form of punishment for certain offences like small offences, petty theft, defamation, things like that. This will ensure that people who are committing smaller crimes or committing crimes for the first time are not straight away put into the prison system, and an opportunity is given to them through community service, working for the society that they live in, to probably bring about a change in their perception of how they want to live their lives. So this can include any sort of community activity. This can be working with the elderly. This can be like planting trees. This is left to the discretion of the state governments or the court to decide what they want to bring under the ambit of community service. Second, say for the crime of theft, a very nuanced approach has been taken. So somebody who is a repeat offender, for them the punishment has increased. It has now become up to 5 years. But for a person who's committing a small theft and is committing it for the first time, so if the theft is equivalent to the amount of 5,000 rupees, and the person agrees to either return the amount or return the object that was stolen, can be let off on community service. So this is an important step, because not all crime is committed because of some great conspiracy and planning. Sometimes crime is also a result of extraordinary circumstances of an individual. So the law has taken a balanced approach as to how to deal with such situations. Similarly, if we look at our prisons, so around 75% of the prison population is people who are under trials. That means their case is still going on. The investigation, inquiry or the trial is still underway. They are not convicted of offenders, but they have spent an excessive time in the prison system. This also happens because of lack of awareness about what is happening in their cases, lack of documentation and lack of legal literacy. So provisions have been made in this to help first-time offenders again. The earlier provision was that everybody who completes half of the sentence that is awarded to them, they will then be entitled to a statutory bail. So this has changed a little bit for first-time offenders. This limit has been further reduced for first-time offenders. Now first-time offenders are entitled to a statutory bail after completing 1/3 of their maximum sentence that they had been awarded. So this helps not crowd our prison system, and also helps people come out of the prison system if they're first-time offenders and get integrated with mainstream society at a faster pace, and which will probably help them not re-enter the world of crime. So another important aspect, if we see, is plea bargaining has been looked at. So plea bargaining is a tool through which one can get speedy justice. So for not very heinous crimes, so crimes which are punishable with less than 7 years, and crimes that are not committed against women, children or the socio-economic conditions. So any other crime which is not either against a woman or a child or the socio-economic condition of the country, or an offence which is punishable for more than 7 years, the accused and the victim in other crimes can come together and decide what a mutually satisfactory decision or resolution can be for the offence that is committed. So the accused is entitled to a reduced sentence, so they don't have to complete the entire sentence. They have to complete only a fraction of that sentence. And secondly, the victim here is entitled to some form of compensation by the accused. So all the stakeholders, the police, prosecutor, the defense, lawyer, the accused, the victim, they come together and they have an opportunity of deciding what can be a fair and just resolution to this case. And in this case also, first-time offender only has to spend 1/4 or 1/6 of the total punishment, which is also a reduction from the earlier present. There was no such threshold for first-time offenders, so it has been introduced for the first time. So plea bargaining has also been made attractive. People who find themselves in such situations, which are probably they're not hardened criminals. They can opt for this, and they have not committed any grave crime. They can opt for this mechanism to get faster delivery of justice. This will reduce court burden. This will reduce delays that occur because of overburdening of our judiciary. And it is a great way in which both the accused and victims get to sit across a table and discuss what they want from each other. Not the accused from the victim, but what the victim wants and what they are entitled to in order to get justice. Now, if you look at the crimes against women and children, so 2 new offences have been introduced which cater directly to the interests of women and children. One is any act where a person is either hiding their identity or making a false promise of marriage or alluring a woman or inducing a woman by giving her the false promise of employment or promotion. By doing this, if they establish sexual relationship with that woman, it will not be considered rape, but it's still an offense because the consent of the woman was not honored. It wasn't an informed consent based on which such relationships were initiated. Hence, it has been made a criminal offense. Now, this is one of the most formidable changes, which gives a very nuanced protection to the consent of a woman. So, consent of a woman is not just
MOPR, WCD, and MOR.
Okay. So, consent of a woman is not mere agreement. This mere agreement should be based on correct facts, correct knowledge, and this law aims to protect women from being manipulated, from being lied to, and using certain tactics to get women to establish sexual relationship with people. Secondly, crime against children. So the act of hiring or employing a child and making a child commit a crime on your behalf has been made a punishable offense with very stringent punishment. So this is a very important safeguard for our children, because children, owing to their age, they are innocent. They do not have the kind of discernment power to understand the consequences of entering the world of crime. And a lot of instances have been seen, especially targeting children within the age group of 15 to 18, making them commit crime. And this fulfills the intention of the hiring criminal also, because he kind of convinces the child that you will not be given very stringent punishment. You can do this, you can get away with this. But for the child, it is very detrimental, because they are exposed to an environment of criminality. They are exposed to a lot of dangers in a very nascent stage of their life. And this has very prolonged, lasting effects on their psyche, on their socio, adjustment levels and how they operate in society. Hence, this is a very important safeguard that has been introduced for protecting children. So if we look at the criminal laws that have are ready to be implemented from 1st of July, you see that certain very transformational steps have been taken to ensure that our criminal justice system becomes more modern, it becomes more accessible, it is more victim-centric, it is more public-friendly, it is accountable, it is transparent. All the authorities are answerable to public, and their regard or their duty towards public has been enhanced. And hopefully, slowly and slowly, this system, as it begins taking shape and form through our court system, through our law enforcement agencies, within a few years, we will see how quickly our criminal justice system has also been revamped, how we are assessing forensic evidence, how much they are aiding in leading to a proper resolution of crime, how the conviction rate goes up. So these are things to look forward to. So I hope all of you educate yourself about these laws, because these laws do affect you. They affect every individual, and they are interesting to read and see and assess for yourself how they will bring about a change. With this, I conclude my speaking time over here, and I I give the mic to Mr. Dayashankar ji, who's going to elaborate more on aspects of women and children through these new laws. So.
Thank you, ma'am, Aditi ji, and welcome to all the participants and senior officers who have joined today from Ministry of Panchayati Raj, Ministry of Rural Development, and all the stakeholders related to Ministry of Women and Child Development, the officials of state government, union territories, the functionaries of one-stop center, hubs, Anganwadi, and all others who have joined today's webinar. So good morning to you all. Madam Aditi ji has told you various facets of the 3 criminal laws that have been passed by the Parliament. And these 3 laws are slated to be implemented with effect from 1st of July, just a few days from today. I would be covering broadly the aspects related to women and children that have been part of these 3 criminal laws. Mostly the focus would be on the new provisions and the provisions where some stringent punishments have been made, or where some new procedures have been prescribed. So my discussion would be on the points that have not been covered by Aditi ji. Next slide, please. So this slide I am not repeating, but I would say that these are the very, very transformative changes, and we'll see its real results in the years to come. Any transformational changes, it takes time to actually get into effect, but I am sure that with increased level of awareness and the government's efforts to make the life of citizens easier as far as criminal justice system is concerned, will certainly lead to positive results. Next slide. Leave it. So, what are the various features? I have tried to summarize it here. So these 3 criminal laws, there are women and child-centric provisions because the women and children constitute about 70% of our population, and they are the ones who are among the most vulnerable sections of the society. So a very positive aspect has been kept in mind while formulating and prescribing the punishments, as well as the with regard to changes in procedure. We will discuss subsequently. Victim-centric approach, that wherever crime is committed against women and children, the women and children will be considered to be a victim, and all the systems will be there in that way. Gender neutral approach has been taken in many places where the minor girls or the terms minors were used. So now it will apply to both. In few places where some of the crimes were earlier considered to be committed by only the men, these have been made gender neutral in view of the changing phases of the society. The technological neutral approach, so all the technological advancements have been very well kept in mind while making the provisions. The focus is on access to justice. As ma'am had already said, that the earlier the Indian Penal Code and other criminal laws, they focused on penalizing the offenders, whereas in the current legislation the focus is on delivering of justice, and it's making it accessible. Cost should not involve much cost, and where the human rights of the citizens are protected, because it has been for the first time it has been seen from the angle of human right violations as far as crime against women and children are concerned mainly. There are enhanced punishments for heinous crime that we'll discuss subsequently. It had been experience of the citizens that they were facing harassment after approaching the police. So those kind of issues have been taken care of, and the foremost point is that ease of living of the citizens has been the center to all the three legislations. Next slide. Here I would like to talk about one special provision that has come into the this Bharatiya Nyaya Sanhita for the this time. So this is about organized crime. So organized crime, particularly if you see in the portion highlighted in the bold, so trafficking of persons is one of the worst forms of crimes against women and children, and this is violation of the human rights of the citizens, where they are trafficked for the purpose of exploitation against their will, for the with the use of force or lure or some kind of incitements. So the human trafficking has been included as a form of organized crime. A new section has been added, and if you see the human trafficking for prostitution or ransom, this is explicitly mentioned because every year thousands of women and children go missing, and if you see the recovery rate of the children are mostly get recovered, but a large number of women continue to be missing, and it is apprehended that many of them have been forced into prostitution or some kind of work that they are not willing against their will. So this has been included as a form of organized crime, and when we talk of organized crime, it means it will be treated as a part of a gang or a group of some criminals, like 5-10 people are there. So whatever punishments have been prescribed, the punishments will apply to all the members of the gang in a similar manner, and the maximum penalty for involving in organized crime is death sentence. And one of the other features of this organized crime is employing the men or children for kind of trafficking of arms or drugs or any other anti-national activities like. So these are part of organized crime. Now, next slide. So stringent punishments have been made. So earlier there were provisions like for rape of a minor girl below the 12 years of age, that was separate provision. For below 16 years of age there was separate provision, and below 18 years of age there was separate provision. Now in line with the provisions of POCSO Act, so all the cases of gang rape of victims under the 18 years of age will be treated similarly, and the next and the stringent punishment including the death sentence will be applied in case of a rape of a minor girl. Gender neutrality, like I said earlier, there are certain crimes which are currently in the Indian Penal Code are said to be committed by men only. But if you see the portions highlighted in bold, like assault on a woman or disrobing or voyeurism against a woman. So these kind of crimes have been made gender neutral, and now even a woman can be treated as an offender if she indulges in such kind of crime. So both men and women are punishable for these offenses. Victim-centric approach. So here one of the points that I would like to highlight, that the ma'am has talked about the plea bargain. But in case of women and children, these will not apply, and the withdrawal of cases cannot be permitted, or a bail of accused is to be permitted only after hearing the voice of the victims. So these are the provisions which have a very, very far-reaching impact, because the cases cannot be withdrawn now unless the voice of the women are heard. Similar is the provision that one provision is there that in case of rape or gang rape or any kind of sexual assault, so the proceedings are now to be held in camera and not in the open court. And in such cases, the due care is to be taken that the victim is not brought face to face with the accused, but at the same time the victim is also allowed to cross-examine the accused person. So these are the kind of sensitive approach that will certainly enhance the confidence of the women and citizens in the criminal justice system. Another provision is there that, like ma'am has already told, that now e-FIR or zero FIR, these have already been prescribed. Obtaining the copy of your complaints or information by the investigating officer within 90 days about the progress of the case on a complaint, these have been made a part of the criminal justice system now. Because of the new advancement in the society, and when the girls are going out for study, for jobs, it has been seen that in many cases they were lured by some criminals or the people with criminal mind who offer them some kind of lure on the pretext of false pretext of promise of marriage, or to offer employment or jobs or a good life in bigger cities, and they take them out of their native places and they exploit them, or many a times hand over them to some criminal syndicates. So these kind of offences have been made a part of the new system. So sexual intercourse on the promise of false marriage, promise of marriage, employment, etc., or by suppressing the identity also. Like a person, if promises or tells that false information about the religion, caste or status or whatever. So if he is hiding his actual identity and indulging in a sexual intercourse, that is considered to be a very serious offense. Next slide. The offenses against children. So, as you are aware, one of the very important points that I would like to highlight here, that in the Indian Penal Code there is an exception under the rape, that if a person is having intercourse with his wife at the age of 15 or above, it is not considered as a rape. But this is in variance with the provisions of POCSO Act, and this provision was long there. Now this has been made equal to that prescribed under the POCSO Act. So now even if a person marries a girl below the age of 18 years, which is in any case prohibited by law under the Prohibition of Child Marriage Act, or for that matter under the personal laws. So the age of marriage for a girl or a woman is prescribed as 18 years. But that was an anomaly that has been removed here. And now if a person in the name of marriage is having a relationship, sexual relationship with a minor girl below the 18 years of age, it will be treated as rape and will be tried accordingly. So this is a very big reform, I should say. Hiring, employing or engaging a child to commit offense. So here this has been seen like as the society evolves, it has been an experience that the criminal syndicates, they hire minors who are in the age group of 16, 17 or below 18 years of age to commit some crime on behalf of the gang or syndicate. So this here the punishment has been enhanced. Minimum punishment will be 7 years, which can go up to 10 years. Another aspect was that in the Indian Penal Code, import of a minor girl for sexual exploitation, that was a crime, but not import of a minor boy. But now here it has been made gender neutral, and now even import of a minor, whether it's a minor boy or a minor girl, it will be treated on the same footing, and there will be a same kind of punishment prescribed for both the offences. Next slide, please. In this slide, we have just for, it is not comprehensive, but just for reference purpose, we have given like where are the enhanced punishments, and in some cases mandatory minimum punishments have been prescribed. So what was happening that in the Indian Penal Code, so punishment prescribed was in many cases up to certain years of age, up to 7 years or up to 10 years. So it was up to the courts to decide what kind of punishment, how many years they want to prescribe. But keeping in view the sensitivity of the crime against women, which the government is very much concerned and giving the highest priority of securing the safety and security of women in the country, their provisions have been made where there have been enhanced punishment prescribed for crimes against women, wherever to come in which are commensurate with the nature of offences. Like for, if you see the example here, the buying of a child for the purpose of prostitution. So this is the worst form of a crime that one can think of. If you are indulging, buying a child is itself a crime, and buying a child for the purpose of prostitution is the worst form of human rights violation. So here the punishment, not earlier, right now it is applicable, it will come into effect from 1st July only. So currently it is extendable up to 10 years. But now under the Bharatiya Nyaya Samhita, it has been prescribed that minimum 7 years of punishment has to be there. And the maximum has also been enhanced from 10 to 14 years of age. Similarly, exploitation of a trafficked child. We have talked about the trafficking, organized crime and trafficking. So here if a person is trafficking a child, so here again the punishment prescribed was earlier not less than 5 but extend to 7 years. Here also it has been enhanced from 7 to 10 years. Though minimum has been kept at the same level, but the maximum punishment has been increased from 7 to 10 years. On the right hand side in the orange section, so here we have listed out some of the crimes that are against women and children where the minimum punishment has been prescribed. So if you see the buying of a child for the purpose of procedure, we have talked minimum 7 years. In case of like organized crime, it has also various facets. So awaiting, if a person is awaiting in human trafficking or attempting in an organized crime, so here also the 5 years has been prescribed minimum punishment. Being a member of organized crime, so if harboring a member of organized crime, so here again it is minimum 3 years. Even if you are not directly involved with it, you have a harboring with the group members, even then you can be punished. So possession of property on behalf of members of organized crime, it has been seen that the crime syndicates or the gangs, they whatever they earn, this has been done basically to earn a profit, economical some kind of benefits deriving out of the exploitation of a person. So they don't keep the property or the money in their names. So they use the services of some other person who are harboring or colluding with those persons, and they keep property etc. on the behalf of some criminal gangs or syndicates. Here again, though you are not directly involved with the trafficking or the exploitation of the person, but still because of the nature of crime, the minimum punishment has been prescribed. Similarly, for begging, kidnapping a child for the purpose of begging, so here also the minimum 3 years, minimum shall not be less than 10 years. So if a person is kidnapping a child for the purpose of begging, so 10 years punishment is there. Next slide. This slide we will share the copy of this presentation with all the stakeholders, all the state functionaries, and my request is that you may get it reached to the every citizens of the country. Translation, if done in the regional language, is better. So here in this slide we have listed out some of the provisions which are specifically related to women and children, and which are the old sections and which are the correct sections, just for ease of understanding. So I am not repeating. These kind of the provisions of Bharatiya Nagrik Suraksha Samhita, whatever has been listed here, Madam has already covered, so we are not. I am not repeating again. But just back. But one very important aspect that is kept in mind is that now you don't have to go personally and submit a written document or signed document in the police station in support of your complaint. You can pass it electronically through messages on your mobile phones or through emails. So good use of technology has been prescribed and made legal under the Indian Evidence Bharatiya Sakshya Adhiniyam, which is currently the Indian Evidence Act. So this information should reach each and every citizen, that they can, sitting at their home, they can send across to police or prosecutors any kind of documents in support of their complaint. Next slide. Now coming to, I will elaborate on some institutional mechanism that will supplement the implementation of all these three new criminal laws. So one of the very important institutions that have been created in the last 10 years, I should say. So in 2015, the government has decided to implement the scheme of one-stop centers across the country. Prior to that, there was no such kind of institution which should serve as a single point of contact in case of first-time responders, I should say, in the time of need. So these institutions have been put in place, and I am happy to share that about 769 one-stop centers are right now functional across the country. And these are providing, the one-stop centers are providing very efficient and very, I should say, appreciable services to the needy women. They provide 5 kind of services like medical aid when there is a case of rape or gang rape or domestic violence or a acid attack. So immediately the one-stop centers can be contacted and they will connect you with the connect the victims or survivors with the medical facility nearby free of cost. Another important facility that is provided, like in case of domestic violence, particularly when the husband or the in-laws, they force a woman to go out of the house. They provide temporary shelter for 5 days, and if there is a requirement of long-term shelter, that is also arranged through our another component of Mission Shakti, that is a scheme for safety, security and empowerment of women, that is called Shakti Sadhan. So through which shelter up to 3 or 5 years, as the case may be, can be provided. Another important service that one-stop centers provide is the legal assistance. So through the Legal Services Authority, the District Legal Services Authority, they provide legal aid and counseling to the needy women in case they wish to file a complaint. So free legal aid is provided. Here I would like to highlight that under the Legal Services Authority Act, free legal aid is a right of women and children who are considered to be most vulnerable sections of the society. So you can avail the services of one-stop centers. Another important aspect is providing psychosocial counseling in case of need, because whenever such kind of heinous act or a kind of violence is faced by a woman or she is in distress, so counseling plays a very, very important role. So they also provide the services of counselors who will tell you or who will make you feel good and happy, and also try to reduce the trauma that you have faced. Next service is like they take care of your all daily needs. So I request all the stakeholders that are joined, who have joined today, to spread awareness about the one-stop centers to each and every citizen, particularly the women in the country, and for that matter to men also, that whenever there is a crisis, there is a need, they can contact their nearest one-stop center. You can also contact the one-stop center through our National Women Helpline 181, which is now integrated with the Emergency Response Support System, which is another project of Ministry of Home Affairs funded under Nirbhaya Fund. The 112 number is providing all kind of emergency responses like police or ambulance service or fire services. But now that 181 Women Helpline and 1098 Childline, they are integrated with the ERSS service. So they provide you seamless services, whether it is emergency or non-emergency. So do avail the services of, remember the numbers 181, 112, 1098, and one-stop centers and contact wherever there is an emergency or wherever a woman is needing any kind of help. Another important institution that the Ministry of Women and Child Development has put in place at the district level and state level is the Hub for Empowerment of Women. We call it Sankalp Kendra. So these Hub for Empowerment of Women, they provide all kind of information and services like schemes of central government or state governments. So we have also asked all the one-stop centers and Hub for Empowerment of Women to spread awareness about the transformative changes that have taken place under the new legislation. But whenever there is a need, you must avail the services. These are available free of cost. Next slide, please. So these aspects have already been covered, so we should not go. Next slide, please, which is kind of, yes. So the children in need of care and protection, you all are aware that for the children who are under the 18 years of age, so they are covered under the provisions of the Juvenile Justice Act. So Juvenile Justice Act has been enacted by the government especially for the children who are in the need of care and protection. And there are unfortunate circumstances where a child becomes an offender, violates some kind of legal provisions and become conflict with the law. So the Juvenile Justice Act, this provides, prescribes the provisions that are applicable to the children who are either the children in need of care and protection or children in conflict with the law. The first and foremost point that is to be kept in mind that the children should not be interrogated or kept in the custody of the police. So under this act, JJ Act, we have the system of Juvenile Justice Board and the Child Welfare Committees. And there are special juvenile police units that have been created across the country. So the children, whenever they are found to be crossing the boundary, I should say, not an offender, so they should be treated and placed before the Juvenile Justice Board in case of conflict with the law, and in case they are children in need of care and protection, they should be placed with the child welfare committees for their rehabilitation and taking care. There are a few provisions like under the Bharatiya Nagarik Suraksha Samhita. Now the children below the age of 7 years, they will not be treated as offenders in case something goes wrong. Similarly, the children between 7 to 12 years of age, so they are also considered to be, if they are not able to, they are not matured enough to take decisions themselves. So even if they have committed some kind of crime or offense, they will not be treated as a criminal or offenders or child in conflict with the law. I have already told that the children should be treated under the provisions of JJ Act, and enabling provisions have been made in the 3 new criminal laws. So these are to be kept in mind while a child has committed any kind of offense. The plea bargain is, I have already told in case of women, and the same applies also in the case of child, that is not available in case of where there is a crime against child. So this is to be also kept in mind. So with this, I conclude my presentation, and I, on behalf of the So with this, today's our webinar has come to an end, and I thank Vivek Bhardwaj sir, Secretary Ministry of Panchayati Raj, for gracing the today's webinar with his presence and addressing the audience. Also thank Madam Smriti Saranji, Joint Secretary Ministry of Rural Development, for your presence, ma'am, and all the officers of the Ministry of Women and Child Development, Ministry of Rural Development, Ministry of Panchayati Raj, officers from states and UTs for joining today's webinar, and my heartfelt thanks to all the participants who have joined from across the country and benefited from today's webinar. My request to you all is that not keep the information that you have gathered today to yourself, but to spread it across each and every region of the country so that it reaches all the villages, every gram panchayat, every urban local bodies and so on, to every citizen of the country. Thank you. Jai Hind.